It is patently unfair for an agency to decide a case on a set of facts which was not presented at the hearing. These were the words of the Review Commission Administrative Law Judge in his written opinion in the case Brigade Energy versus Secretary. When an unexpected explosion occurred at an oil well in Grassy Butte, North Dakota, two employees, each from different companies, were involved. Brigade Energy's employee held a wire line used to detonate the charge. Its contractor, KLX, assigned one of its employees to direct a perforation gun. OSHA issued a citation against Brigade Energy under the Explosives and Blasting Agents Standard, as well as under the General Duty Clause. At trial, it came out that Brigade's employees had actually helped to lift the perforation gun over the well. This fact, however, was not a part of the alleged violation description in the citation. Today, we'll discuss how the judge handled this mismatch between the evidence at trial and the alleged violative facts in the citation in the case Secretary versus Brigade Energy Services. I'm Manesh Rath, and you're a part of the February 2026 edition of the OSHA 3030. Well, hello, everyone, and welcome to the OSHA 3030. As I said, I'm Manesh Rath. I'm an attorney at the law firm Keller and Heckman here in Washington, D.C. And for over 30 years, I've represented management side in fields of workplace law, particularly occupational safety and health law. I'm very fortunate today because I'm joined by my friend and colleague, Ben Idzik. Ben, welcome to the OSHA 3030.
Thank you, Manesh. It's always a pleasure to be on. Appreciate the opportunity.
Well, Ben, we have a pretty interesting topic today, and it applies to more than just the blasting agents standard, the explosives and blasting agent standard. It really goes to the question of whether or not OSHA can expand the scope of its alleged violative description at trial, or whether or not the evidence that is presented at trial is limited in its utility for the purposes of establishing a violation by the contours or the framework of the alleged violative description itself. That is a question that applies to every OSHA citation that gets tried, without regard to which standard that is being tried in any particular case. So, because of its broad applicability, I think this is a really important decision.
Yeah, it involves a pretty niche area of oil and gas, the oil gas industry, but I think the lessons that can be learned are definitely universally
I
applicable.
think that's right. So the facts of the case, I think, are important to understanding this particular case. We're going to get a little bit into the oil and gas facts as well as in this particular case, as well as the particular standard. But really, just so we understand how the judge ruled, because as you say, Ben, the ruling itself is applicable to every standard, every industry, every sector that's regulated by OSHA. I think. Then I think we should talk about how OSHA established a violation or tried to establish a violation of the specific standard. Ben, I think you should talk a little bit about the fair notice doctrine, which is really why we're here today.
Yeah, we'll talk about the fair notice doctrine. We'll also cover a principle that sort of came up as well, known as the preemption principle, with regards to a specific standard and the general duty clause as it relates to the legal basis behind a citation. And we'll conclude and with discussing the ALJ's decision in this case, how he ruled on these issues, and conclude as always with the what employers should do section.
Well, why don't we get into it? Let's start with some background. So this involves a oil rig in Grassy Butte, North Dakota, and Brigade Energy was engaged for the purpose of abandoning the well. The proper abandonment requires plugging the well first, and so that once abandoned, there isn't any leaking of ground rock gases, etc., into the well or contaminants from the welling operations into groundwater that might be nearby. That the material can find its way, migrate into. So that plug-in abandonment project was led by Brigade. Brigade was known as the workover crew.
Right. And what brigade would do is, like you mentioned, Manish, they were in charge of taking the machinery that's inside the well and retrieving it from the well. And they were joined by another contractor, KLX. And KLX's role in the plug and abandonment operation was to insert what we'll discuss later, known as a perforation gun, inside the well and at a predetermined depth, have that gun be detonated in a manner to seal the well from the inside to allow it to be abandoned in a safe manner.
So KLX is handling the detonation with the perforation gun. It manages the perforation gun. All Brigade does is, as the workover crew, is it prepares the well for abandonment. It prepares the derrick itself, and the derrick is elemental in the abandonment process all through because the perforation gun is lowered into the well, and the derrick is used to rig it. But after both of them are done with their jobs, the final step is plugging, which is a cement operation. And so a third crew comes in, a cement crew, and fills the abandoned well with cement, and that also requires the rigging. So brigade is responsible throughout for the rigging, meaning the derrick and anything attached to the derrick for purposes of lowering and raising. And so that's their job, and their subcontractor KLX provides the wireline operations. This is the management of the perforation gun. It gets lowered in to the well and perforates the well bore. By this time, Brigade has already removed the casing, the piping that goes into the well, and as you said, all other equipment and drilling equipment. And so now it's a bare bore, and KLX will use the perforation gun in the bore where the casing has been removed. Those two organizations, employees, must work hand in hand. It's a integrated operation between the two of them. Signaling has to be unified. Managing the safe zone and the danger zone has to be managed in a unified manner. And all the safety policies, for example, employees of both organizations are not permitted to bring mobile phones to the area during this perforation gun blasting operation. Uh, so, so that has to be coordinated, and they have to have a unified and integrated sort of approach to everything they do. So that's, I think, a pretty good background for why those two contractors are there.
Right. So we get to the incident, which occurred on November 3rd of 2021. And during that day, one of the brigade workers that was near the operation assisted KLX while KLX was preparing the perforation gun to be loaded inside the well. And what the worker did is he held the cable portion of the gun while it was being connected to a steel tube that housed the explosives that were eventually be detonated. And I think that's an important distinction when we look for this case is that this gun was assembled on site, but the explosives and the charge were separate, and they were connected on site, and that was what eventually made it an explosive.
That's right. The steel tube, known as a carrier, contains the explosive material, and on top of that is a blasting agent or an initiation device. And that's at one end, and attached to the initiation device is a cable that is used for two purposes. One, to lower the perforation gun into the wellbore, and another is it's a conduit, it's an electrical connection that triggers the blasting agent. The job that was alleged to have been performed by Brigade's workers was the handling of the wire line. And the handling, as alleged in the violation description, of the explosive agents that were in the carrier was handled by a KLX worker.
Right. And I think that's sort of what the crux of this case comes down to.
The allegations raised by OSHA were that the brigade worker did not handle any explosives.
Mhm.
Only a worker from KLX did.
Right.
That's the boundaries by which the case should have been confined because that was the citation that was issued by OSHA, and that was the citation that was contested by Brigade, therefore.
Right. And the citation that was issued was both under the blasting and explosive standards, like you mentioned, and also under the general duty clause, which is sort of an interesting dynamic because under one, you have to prove a specific standard. Under the general duty clause, you have to prove that there was an unsafe condition on the property that the employer failed to mitigate.
That's right. Let's talk about what OSHA has to establish when attempting to prove a violation of a specific standard. In that case, they need to establish that the standard itself applies to the alleged hazard, and that the standard or the terms or conditions of the standard were somehow violated, and that there was exposure to a hazardous condition as a consequence of an alleged violation, and that the employer either knew or should have known with the exercise of reasonable diligence that the violative condition existed, or that the employer knew or should have known that there was exposure to the violative condition. Those are the kinds of things that OSHA has to establish with a specific standard as the subject of a citation. Now, the elements for a general duty clause are different. And as you say, Ben, in this case, OSHA alleged a violation of both the specific blasting agent standard as well as the general duty clause in the alternative. In the event that the standard doesn't apply, OSHA said, we think that at the very least, they still violated the general duty clause.
So when we talk about the fair notice doctrine, we see that it really stems back to due process rights, and what that means is that OSHA has to identify when establishing a violation what the violative condition is and when the violative condition existed. And the purpose of this, as we definitely see in this case, is to allow the employer, the defendant, an opportunity to prepare its case and defend it through effective cross-examination, through interviewing the proper witnesses. The underpinnings that we see in just general law is certainly present in these OSHA contexts.
Well, that's right. If an employer is still scrambling right up to the eve of trial or during trial to figure out what the theory of law is or what the alleged facts are that constitute an alleged violation, then by the time it is able to present its defenses or even evaluate what defenses are apparent to it, it may be too late to galvanize the evidence and the witnesses it needs to bring that defense to bear. And so I think that as a general question of due process, it's imperative that the person or party against whom an agency brings a alleged violation, an allegation of a violation, has the opportunity to know what the allegation is, to know what they're going to have to defend, what they're going to have to contest, and what they're going to have to admit to. So with that said, let's talk about the preemption principle.
Yeah, that's another one that came out like we just discussed in what OSHA did here. Like you said, they issued a citation under a specific standard, the blasting agent standard, and in the alternative, they also alleged a violation of the general duty clause. And this principle comes to mind. This principle it states that OSHA cannot rely on the general duty clause as a fallback position if the condition under which the general duty clause citation is based off is applicable under a specific OSHA standard. The idea here is that if OSHA proffered regulations covering a specific hazard, then that standard and its terms have to be used when making a citation as opposed to the more broad general duty clause.
And to be clear, Ben, this is not a legal requirement. This comes from their own enforcement doctrine, but it is a very well-established enforcement doctrine. One thing that has not come up very often in review commission decisions, and I've read hundreds and hundreds and hundreds of review commission OSHA law decisions, and I think you have to go back to 1976 to the case that this judge cited to find another example where it came up, that establishes that although OSHA may not plead an alleged violation of the general duty clause where a specific standard exists, it may actually plead in the alternative a specific standard and a general duty clause. And so I think that this particular case that we're talking about today, Brigade Energy, is really important for this principle that OSHA may in fact plead in the alternative a specific standard and a general duty clause violation, so that if one doesn't work, they still have a fallback. I think that that is something that, again, just off the top of my head, in the hundreds of cases I've read, I have not seen happen in a long time. And the 1976 case, Henkels McCoy, that the judge cited for this proposition is it may be the last time that it came up. So let's keep going. So when OSHA gets to trial, it presents its arguments, and one of the arguments it made was the the perforation gun, in concert with the wire line, created a system. And although Brigade's employees were not alleged in the citation to have handled the carrier, which contained explosives, because they handled the wire line while KLX's employees were handling the carrier, they were nevertheless handling a system that collectively qualified as an explosive device, and therefore the standard should apply. Brigade's response was the standard would not apply because the standard only applies to the handling of explosives. And a cable is not an explosive. And if that is all that has been alleged as to what Brigade's employees handled, then in the citation, then they weren't doing any activity, engaged in any activity that would be covered under the explosive standard. I think that that is a good defense on the question of does the explosive standard apply to anything that any activity that Brigade employees engaged in?
I think it's also interesting to note that later on in the decision, Brigade also argued that even if the standard did in fact apply, the workers' handling, Brigade's handling of the cable did not actually create the hazard that the standard itself is designed to protect.
Right. When you get to the trial, however, and you move from the facts alleged in the violation, it comes out that Brigade employees actually did handle more than just the wire line, that one of their employees helped a KLX employee lift the perforation gun into the well. And OSHA raised the allegation that that was a violative condition because they were handling explosive at that moment and that they didn't have training to do so, etc. Um, the administrative law judge parsed out his decision, having heard both sides, in steps. First, the judge asked, does the standard apply? Since blasting agents were being handled, the judge argued that the standard does apply. Because the alleged violation description stated that all Brigade employees ever did was handle the wire line, the judge then next ruled that the standard applies and Brigade employees didn't violate the rule. The next step for the judge was because the standard applies, the general duty clause does not apply. You can't have both. This is the preemption doctrine you were talking about, Ben. And finally, the judge ruled as to the facts that arose first at trial, that indeed Brigade employees did more than handle just the wire line, and that that would have qualified as potentially, arguably, a alleged violation. The judge said, well, you need to have alleged that in the citation, or else Brigade would not have had fair notice, and in this case did not have fair notice as to what the alleged violative act was. And they could have mounted a defense as to that had you done so. And lacking fair notice, it would not be appropriate to find a violation in the middle of the trial. So that's the administrative law judge's decision, and it really requires that you parse it out in those four steps in order to grasp, I think, what is really the important part of this decision for all employers outside of the oil and gas sector, every sector. And that's this last step that even though, on one hand, the judge found that the standard applies, and on another hand, found that handling the wire line would not qualify as a violation, and on another, that indeed Brigade did more than just handle the wire line. They handled explosives without the proper training. That nevertheless, that last arguably violative act, a citation could not be affirmed because it wasn't in the citation, and that Brigade didn't have fair notice that it should be. I think that's an important defense and an important opinion from the judge that I will be looking at when evaluating every potential OSHA citation contest henceforward. I think this is going to be a landmark question.
Yeah, and it's certainly something that, like you said, I think it's sort of an intuitive thing. You have to be able to understand to have a fair opportunity of defense to what exactly OSHA is alleging is constituted of a citation, and it's
Right.
something that employers should take a look at anytime they're dealing with a citation.
Yeah, I think that's right. Well, let's talk about what employers should do in light of the Brigade Energy case.
After a citation is issued, make sure that you as the employer conduct an independent post-incident investigation to verify OSHA's account of the alleged violation. It's critical because if you don't have that evidence at the front, you're not going to be able to then bring it up later to undermine what OSHA's alleged allegations are.
Right. And when you receive a citation, I think employers, it's important to look at the citation, figure out what your defenses might be, work with legal counsel, and consider collectively with your OSHA counsel whether or not the alleged violation description alleges an act or omission that matches with the allegation of who the responsible party is. When you have multiple parties on a work site, as Brigade and KLX were, it's important to match the alleged act or the alleged omission with who the alleged responsible party should be. The other thing I'd say is I think it's very important to carefully consider both between the employer and its internal experts and your OSHA counsel whether the scope of the standard even applies to the alleged hazard. I can't think of a single standard that we have contested where that's not the first question on my mind. Just look at the scope of the standard and just try and determine whether the activity in question qualifies either outside of the scope of the standard or as one of the exceptions to the standard. And finally, I think it's important to evaluate whether or not the presentation of evidence by OSHA during the discovery stage, the pretrial discovery stage, or at trial itself, goes beyond the bounds of the alleged violation description, in which case, here at this moment, it is imperative to consider whether or not to raise a fair notice doctrine defense. I think that that is the most important takeaway from this case, and this case will continue to stand for that proposition. Well, that's today's OSHA 3030. Please, when you get the invitation to the next OSHA 3030, forward it on to 3 other people within your organization and at other organizations, safety and health professionals, as well as in-house counsel responsible for OSHA compliance, EHS compliance. Our next program will be on March 25th at 1 p.m. Eastern, and we look forward to seeing you then. We already know what topic I think we're going to have. It's an incredibly important subject that applies to almost every employer. So please watch this channel for the announcements for the March 25th date and share it with your colleagues in-house as well as at other organizations at your trade association and tell them to spread the good word. We have sister programs, the Reach 3030 and the Tosca 3030. They're both scheduled for February 25th at 10 a.m. and 1 p.m. Eastern, respectively. If your organization is responsible for compliance with REACH or with TSCA, make sure you forward this on to your colleagues who are responsible for that compliance program. With that said, I want to thank all of the staff here at Keller and Heckman who helped put this edition together. I want to thank all of you for participating in another month's edition of the OSHA 3030, and I also want to thank you for forwarding on our invitations to at least 3 people every single month. Ben Idzik, I'd like to thank you for joining me on this OSHA 3030, and we look forward to seeing all of you again next month, March 25. And until then, stay safe.